Bird versus Wells Fargo. I'll be reading you the June 15th, 2017 decision. A little background behind the case. March 31st, 2017, Wells Fargo was, they were ordered to immediately design and implement a discovery plan to, in good faith, comply with the order that was 14 days before this, June 1st, 2017. The order detailed how discovery in this case had broken down, specifically set out the scope of discovery, and ordered Wells Fargo inter alia to produce 11 sets of documents by June 1st. So pretty much after they didn't do what they were told the first couple of times, they were given another chance. So let's see what Wells Fargo did. So pretty much what happened was Wells Fargo did their own thing again. What was said was Wells Fargo took the position that on relevant data was from 2005 to present, falling within 3 categories. And the 3 categories were information taken without authorization, category 2 was non-electronic, and category 3 was burglary and robbery. This is what the court issued. The court issued a discovery order defining the scope of discovery and ordering Wells Fargo to produce, among other categories of documents, all compromised data reports regarding employees who failed to comply with the Wells Fargo's information security policy from May 6, 2012 until May 6, 2015, along with any explanation of codes or data to understand such reports. So, once they were told to handle the problem, come up with the plan, give it to them, Wells Fargo had already said that they would produce 52 documents. This is what they said. And we have agreed to produce these reports on the Policy Works database from 2005 to the present. And there are 52 reports, including Ms. Bird's, and we will produce those in Excel format so we can. The reports are quite long, so that's the most easily maneuverable way to produce the reports, and they have all the information on the Policy Works database, and we will agree to produce that. So that's what they agreed to produce. So this is really what happened. They failed to produce the 52 documents that had already agreed, any information from the Policy Works database, or a single compromised data report. Instead, it explained in its joint statement to the court that it had interpreted the court's order to include only the physical compromised data reports and not the exact same data to the extent reflected in the Policy Works database, despite its representation that all of the information of these compromised reports are in the Policy Works database. So once again, Wells Fargo is doing their own thing. Now I'm just going to read you. That was just pretty much the background. So pretty much what's happening up to this point is Wells Fargo needs to come up with a discovery plan. They need to implement it. They haven't. They've been given more time. They still haven't. So this is the conclusion from June 15th of this year. The 52 documents and all that was supposed to be done by June 1st. So now they've had to come back June 15th, and this is what the court said. Conclusion 1. Within 6 weeks from today, Wells Fargo shall complete the following production. Wells Fargo shall also submit a statement of compliance with the court, along with the explanation of any failure to comply. 2. Wells Fargo shall produce all data regarding employees who fail to comply with the Wells Fargo's information security policy from May 6, 2012 until May 6, 2015, using the method proposed in Wells Fargo's email of June 7, 2017. 3. Wells Fargo shall also produce the 52 records from the Policy Works database, which it already agreed to produce, as discussed in the March 30th, 2017 hearing. So that shows you right there, March 30th, 2017, You've got multiple chances to give what you said that you would give, and you still haven't. Number 4, Wells Fargo shall provide plaintiff with a sworn statement regarding the total number of records in the PolicyWorks database falling under each category in the PolicyWorks database, including each category identified under category levels 1, 2, and 3 from March 6, 2012 until May 6, 2015. This document should list the name of each category and the corresponding number of entries associated with the category for this time period. Okay, number 5. After 6 weeks, plaintiff has leave to file a renewed motion to compel or a motion for sanctions regarding data relating to other Wells Fargo employees who violated Wells Fargo's information security policy. If it believes that the data remains insufficient to determine its claim in light of the burden involved in production, or if Wells Fargo fails to comply with this order, and number 6, to the extent that a party interprets an ambiguity as to this order, the party shall promptly contact the court to arrange an informal discovery conference to resolve any such ambiguity without delay. So if you're coming up with a problem, then let us know so we can go on and set up an informal discovery conference, come up with a game plan, and you can get discovery done. So my opinions about this: I do not agree with the court at all. This has been going on for way too long. So for one, court orders must be followed. Wells Fargo is simply just doing what they want to do. How many extensions will they be given before the judge rewards the plaintiff? Okay, my second opinion: the court is failing the public due to time and money. They're failing the public by continuing to handle the same matter when there are major problems to address. The public have to continue to come to court for extra stress in their life. The jury has to continue to come to court. The attorneys have to continue to come to court. The parties have to continue to come to court. The judge has to continue to look at the same thing. It's just more stress. And the tax dollars and personal money spent for court and attorney fees. Every time you go to court, more attorney fees, more court fees, more attorney fees, more court fees. And my last opinion: time and money of e-discovery by itself. It takes time to conduct work, which is a cost in its own. Now you also add the cost of producing the actual e-discovery. So now you have to spend the time to do the e-discovery. You have to spend time to produce the work discovery. You have to take time to figure out how to, say for instance, it's on a flash drive. The flash drive is corrupted. Now you have to spend money to go get it uncorrupted, get it cleaned, see if you can even see anything on it, and that's time and money. So at the end of the day, my opinion is the court systems are being way too lenient. Law is like the Bible, black and white. Whenever you give extensions, you're painting a line of gray. That's what you're doing. So my thing is award the plaintiff, because Wells Fargo is pretty much trying to do their own thing. Thank you. I hope you enjoyed. Felt like I was rambling on a little bit, but thank you.